Hi everyone. So I hope you enjoyed your 20 minutes breaks. You took a good coffee or a good tea, and we are back for the Privacy Engineering Conference. So thank you to follow us on that. We welcome Romain Robert, who is member of the Belgian Data Protection Authority, lawyer specialized in IT law, and most of all, he now works at NOYB, which is none of your business. Hello, Romain. How are you?
Hello. Thank you for having me. I'm fine. Thank you.
Great. So I dropped you the mic because you will speak about SDK and data protections. So what should we care? Good luck with that.
Thank you. So I guess I'm one of the only lawyers in the afternoon. So I try to make it as as let's say easy to understand as possible for non-lawyers, because interaction between privacy law and data protection law and technology, and especially SDK, it's quite difficult to understand both for lawyer and developers, I think. But first, I would just maybe make a quick introduction about NOYB. What is NOYB? Sorry about it. NOYB is an NGO based in Vienna. It stands for None of Your Business. We are privacy NGO focusing on the enforcement of data protection law, and especially the GDPR and the EPrivacy directive, which are both texts voted at the European level to protect privacy and data protection. Data protection, for those who are not familiar with it, it's not about security, or not only about security. There is only a few articles and provision in the law about security. Data protection is more about what you do with the data, how you can collect them, what is the legal basis to collect them, how long you can retain them, what can you do with the data, to whom you can share the data with, and so on and so on. So that's a little bit what we do at NOYB. We basically an NGO based, so as I said, in Vienna, and created 3 years ago when we were only 2 persons. Now we are 70 persons with 9 data protection lawyers from different EU countries. I'm personally from Belgium, some colleagues are from Italy, Austria, Poland, Germany, and so on. We are basically filing complaints before the Data Protection Authority, so like the CNIL in France, when we identified a serious violation of data protection law. I could refer to a cookie complaint. So if you go on our website, because I think I can share it in the chat now, I will share the website of NOYB. You can have a look of what we do in our daily activity. And this is the link. And a nice product that you can see is, for example, the cookie product that we launched last year. We are intending to file 10,000 complaints against website not complying with the cookie laws. So it would be like, on average, I would say 50 complaints for each data protection authority in each member state of the EU. I will now share the link in the chat about this campaign about cookie complaint, if you're interested. So what is NOYB also? It's also an NGO, it's a civil society NGO trying to fill the gap between the theory, which is a nice law that nobody really enforces, and the practice, which is obviously a lot of practices which are not compliant with data protection law. We're trying to support businesses as well, and especially SMEs, not really support them directly, but we want to make sure that privacy law and data protection law is compliant with by everyone, and not only the small ones and the big ones, and we know who are the big ones. So to make sure that the citizens are just protected enough by the EU law that has been passed 4 years ago about data protection. So that's a little bit what we do. Just for information, we also created recently a foundation in the Netherlands to do the equivalent of class action that are existing in the US, but there is no such thing as class action in the EU. It's more called collective redress, but it's a little bit the same thing, to go not before the authority, but also before the court. So just to make huge claims, usually against the huge companies when they don't comply with data protection law. So I would just pass this slide because I think we are short of time for that. The first thing that I wanted to explain about what is the interaction between SDKs and GDPR, and especially the ePrivacy law. So I guess everybody already heard about GDPR, which is the General Data Protection Regulation voted by EU. So it's a EU law. It means that basically 95% of the law is applicable in all member states or all countries of the European Union. So it's the same law and the same articles and the same provisions. These provisions are also harmonized and interpreted in a harmonized way, let's hope, at the EU level by a body called the EDPB. So they're just trying to make sure that all these laws are interpreted the same way. And they provide guidance and guidelines for the companies and organizations having to deal with data protection. It might not be obvious for everyone that SDK might imply data protection, because for some people, SDKs are not processing personal data. But I want to remind that the definition of personal data is quite broad. And it doesn't mean that the data is personal when you have a name or address or whatever. Personal data is any data that can be linked to a person. So you understand that in the use of SDKs, wherever you have a location, an ITFA or Google ID, a cookies, a picture, phone number, this is considered as personal data. So a lot of personal data are used and sent by the SDKs, meaning that the GDPR and the ePrivacy law, which is a complementary law focusing on electronic services, are applicable. So that's a common mistake that is usually done, that when you do SDK, you just don't always think that personal data is processed, but it's usually not the case. Second thing that I wanted to clarify, that's about the ePrivacy Directive. As I said, the ePrivacy Directive contained a specific provision called the Article 53, and it's what we used to call the cookie provision. I'm sure you all already know all the rules about cookies and everything, or maybe you heard about the rules about cookies, that you have to place a cookie with consent and full information of the data subject being the user here. The cookies law is not only applicable to cookie, but as you can see in this definition, very legal, I admit, is that any storage or access to an information on the terminal equipment, meaning, for example, the PC, but also the telephone, the smartphone that you have, is subject to the ePrivacy. So any writing, accessing, or storing on a smartphone is subject to the ePrivacy rule. And the ePrivacy rule is even more strict than the GDPR, because it requires consent if you want to process data through an SDK, or you can also process the data without consent only for the purpose of carrying out, facilitating the transmission of communication over electronic communications network, or when it's strictly necessary to provide the information society service. So you understand that the huge debate will be about what is strictly necessary. And of course, accessing your agenda, accessing your email when it's not necessary to provide a service, like the weather application, is definitely not necessary to provide a service. And in this case, you will need the consent of the user. The next slide will be, and I see already a question. Who is subject to the GDPR and ePrivacy? So that's what we call the controller in the legal term. The controller is the entity or organization that determines the meaning of the purposes. So it's usually the app developer, so the person just launching the app or developing the app, and maybe using SDKs and libraries from other provider. But it might also be the SDK provider, since the data will be sent to the provider, and this SDK provider will also be subject to the GDPR as a controller. We have a recent decision about Grindr, and I would just maybe send a link to this decision if you want to have a look. It's in English, by the Norwegian Data Protection Authority. We just wanted to find, it's not very useful for everyone. Let me share this link. On this link, you will find a decision in English by the Norwegian Data Protection Authority against Grindr, where Grindr is subject to a fine of 10 million euros for using SDKs without consent, without information of the data subject, and no free consent from the users of the platforms. In this case, the DPA, the Norwegian Data Protection Authority, seems to consider that both Grindr and the SDK provider might be call what we say joint controller, meaning that they are both responsible for what they do with the data, and we don't make a separation between who is doing what, because they all do that together. It's like a, it's like a cooperation between who is sending the data, who is developing the SDK, and who is using the SDK in the process. Another definition under the GDPR, but it's not that important in this case, is when you're not a controller, you call a processor, and you're not that responsible for the data. And it's basically when you are hosting your SDK data in a cloud service provider, for example, the processor is the one dealing with the data on your behalf. Again, choosing a processor is very important because it's always the controller at the end which is responsible for processing the data. Same example of on a website, it's the website owner, the developer of the website, which is the responsible person for all use of the cookies on a website, for example. So it's not because you just use OneTrust or any other cookie provider that you're not responsible. Choosing the processor is one of the responsibility of the web owner. You cannot leave this responsibility by just saying, oh, I just leave it to the processor. I was trusting them. They were just doing good things and compliant things with the data. No, it's always the web developer or the app developer, which is at the end responsible for complying with the GDPR. First requirement when you just process personal data, and as I explained, there is a lot of personal data processed by SDK, you have to inform the consumers about which data you're processing, and not only like a huge vague categories of data. You really have to explain which kind of data are processed by the SDK and by the app, and for which purposes. For example, formulation that are not specific enough, like improving user experience, and we've seen it a lot in the privacy policy, is not considering to the reading the opinions of the regulators, is not precise enough. You can just say improving user experience. What does it mean? As a user, I don't really understand what you do with the data. And I see that, for example, the Vinted privacy policy is referring to this kind of vague purpose. Also, securing the service is not really something that is precise enough. How do you secure the service? By accessing my agenda, for example. You have to explain what is the link between the data that you collect and the purpose that you want to use for, and the purpose for which you want to use the data. Information also include the list of the recipient, but also not only of this, like we would just send it to our partners. It is not precise enough. Then I will also refer to the Norwegian DPA decision that I just mentioned in the link. The Norwegian DPA decision also consider that list of recipient is a minimum that you have to have in your privacy policy, especially as an app provider. You have to list all the recipients of the data through collected and sent through the SDK to the users. Just a vague definition of like, we're going to send it to our partners again is not enough. Why is it important? Because of course, as a user, if I don't know to whom you just send my data, I will not be in a position to exercise my right, meaning my right to access the data, my right to delete the data, or just as a principle to know where my data are staying with. Another requirement, and I just already mentioned it, is that you need the consent from the users when you're not in the two cases that I just mentioned, where it's necessary to provide the service. And again, it's not because you need a GPS location to provide a service that you can use an SDK about a location that is not compliant, meaning an SDK where you're just collecting too much data or sending the data outside of the EU without any safeguard. And we'll just go back to that later. So first of all, you need to have a consent which is specific, but also minimizing the amount of data that you're collecting. The consent, the conditions to have a valid consent under the GDPR, to have a legal valid consent, is that the consent must be specific. It can't be general, so you can't say like, I'm going to use your data for whatever purpose, or like just to answer the improve the service. I already mentioned it. It has to be freed. It means that it cannot be tied to the service, and we have also that in the Norwegian DPA on Grindr that I already mentioned, because it's one of the first decision of a regulator about the use of SDK. That's what I'm referring to it a lot. The use of Grindr was not possible as a free service if you were not obliged, if you were not consenting to the data. So this consent was not considered as free by the regulator in Norway, because you cannot use the service if you don't consent. And it is not allowed by the GDPR. Consent has always to be free. Otherwise, it's not a free consent, right? Unambiguous means that you have to know what the consent is exactly about. So you really have to understand what is the consent, and it has to be informed. I already, I think, explain what the information has to include. And of course, you also have, and not of course, it's not maybe obvious for everyone, but the GDPR also express that you always have the possibility, should have the possibility to withdraw your consent as easily as you consent, basically. So it can't be more difficult to withdraw the consent than to give the consent, which is something that you usually do with the cookie thing, right? So you consent with the cookie and you can't find how you can withdraw the consent. Same thing with the SDK, since the law is the same. And I know it's a lot of requirement and it might be news for everyone, but sorry about it. It's also very important to be aware of that. There is a specific category of data that we call sensitive data in the GDPR, and they are usually the data about your political views, sexual orientation, religion, and ethnic background. One nice example is the current application. It was a Muslim prayer application, and thanks to our dear friend from EPrivacy, I guess you already know this French NGO, we are doing a great job about exploring the SDKs and the application to know where the data are just sent and to which SDK providers. They realized that the current application was sending location data of the Muslim prayer to the US Army for reasons that were not really obvious for everyone. And we might suspect, of course, that the US Army wanted to make sure that the Muslim suspected of terrorism were located wherever they were using the application. So this kind of sensitive data usually cannot be used by an application. They need a specific consent on this specific sensitive data. So you need a consent of the other data and also another consent on the use of the sensitive data. And the condition to use them is even stricter. As another principle that is also to be respected under the GDPR is what we call the principle of data protection by default. That means that whenever you just do an application or a website to the users, you always have to embed directly in the the settings of the application by default the most data protection friendly configuration, meaning that you cannot presume that consent has been given and then only provide the user to opt out for consent. It has to be an opt-in. So every solution that is developed should be by default set to the highest standard of privacy and data protection. Same thing for the principle that we call data protection by design. That means that as soon as you design the application or the website or whatever thing that you design, data protection should be embedded as from scratch. So you have to make sure that the way you design an application is always keep bearing in mind data protection from the start of the development. Another principle which is applicable to you, and I don't have time basically to just go all the principle, of course, and I can't just give a legal advice in 20 minutes. And that's why I think lawyers are there for. The same one as I guess you would consult for copyright infringement if you develop a program or an SDK and everything. Here, I understand that data protection is also an obstacle for developers and the IT sector, but it's not new. It's not the only regulation which makes things difficult, I would say. And as you know, it's a trendy area, is the goal of data minimization. Data minimization is a principle according to which you can only connect the data necessary for the purpose, not more, and only to the extent necessary for what you're using the data for, that we call the purpose of the data. And then another principle which is also quite important, and it's especially for NOYB as an organization, because NOYB was really involved in what we call the Court of Justice decision, the Schrems 1 and Schrems 2 decision, when the Court of Justice, which is the Supreme Court of the EU, confirmed that the transfer to the US could not take place on the basis of an agreement between the EU and the US. They just struck down what we call the privacy shield, and you have to rely on other instruments, like, for example, what we call, and I'm sorry if I'm too technical, standard contractual clauses that are contractual clauses approved by the EU Commission, and they has to be signed between the exporter in the EU, it can be the app in the EU, and the importer of the data, being, for example, an SDK provider located outside of the EU. And why? Just to make sure that the data, once they leave the EU, they will not be subject to the protection of GDPR, remain subject to a protection by virtue of a contract. So that's another requirement. And I also can refer to the complaints that we file against the website using cookies, because they were using cookies from Google Analytics or Facebook Connect that were obviously data sent outside of the EU without using all these compliance standards. So what the action that we can expect from NOYB? As I explained already, we just do complaints, but also collective redress in court. I just refer to the cookie campaigns that we already did in the past. And we are actually working and thinking to go after SDKs, meaning that we would like to use an instrument, for example, the Exodus privacy instrument, to see whether all the SDKs used in the application and the libraries are compliant with the GDPR. I would refer to the report called Out of Control, prepared by the Norwegian Consumer Council, which is like a Norwegian consumer organization. We work with them, and that's what the basis for the Grindr complaint, when they explain all the problems that you can have with SDKs and compliance in terms of GDPR, meaning that some applications are using SDK and basically the data are just out of control. They just send everywhere in the world to unidentified partners and everything. It's really difficult for them to know what the data are just sent to. And the last slide, I'm just trying to be in time, is maybe some resources. So I just would refer to this Exodus privacy website that I really like, because it just explains what the SDKs and the application are doing with the data. To this report of the Norwegian Council, Out of Report, that I'm just think is really nice to read and quite easy to understand. Also to mention that if you have any question, you can also, of course, just contact me online. And this is also the link to our website, noyb.eu, where you can find a lot of information about what we actually do as an NGO.
Thank you very much, Romain. It was very interesting. And we have 3 minutes left for the Q&A. So some people ask questions in the chat. We have Abdelkrim who asks, is it true that Facebook SDK is not compliant because it drops a cookie before asking for consent?
As far as I understood, there were some SDKs from Facebook dropping the cookies and some were not. But of course, if you drop a cookie, meaning it's exactly what I explained. If you're just violating EPrivacy because you don't have consent. And to my knowledge, but again, it has to be discussed case by case, is Facebook Connect very necessary to provide the service? That's another, of course, that's another question. Do you really need Facebook Connect? And I see that we have another question about, is this Norwegian decision can be a jurisprudence of a European? For sure, because it's more complex than that, because the Norwegian DPA is the only one to do that now, but it's more than likely that the other regulators will follow the same approach, like the CNIL and the others. It's just that they didn't receive any complaint and everything. I said, NOYB want to fill the gap, and we intend to go and to see whether we can also enforce the GDPR with the use of SDKs in applications. As an example, we already contacted an e-signature application in Belgium. They were using Google Analytics, and they accepted to withdraw Google Analytics, because I just explained to them, guys, you cannot send the data of the user, the citizen, using the e-signature for the public government to Google Analytics. Why? Why do you need it? And they say, oh, it's easier. Yeah, but easier is not necessary. You know what I mean? It's always, it's not because it's easy that it's necessary. Easy is not, under the GDPR, an excuse to use a service which is not compliant.
Yeah, and I have a last question. It's more about how you do your work to prove that there are privacy problems in a specific SDK. Do you dig into code, or is it just by reading the terms of services, or how
both,
do you
of
do
course,
that?
because what we can see that usually like in the Grindr case, for example, we read the code. So we have tech people that working in NOYB as well. By the way, we're hiring, if you're interested, another tech guy. but also the lawyers are reading the privacy policies and we're trying to make sense out of it. And usually what we see, was we saw with the Grindr case, for example, is that the privacy policy was not complying with what the SDK was actually doing. So first, the privacy policy was not compliant, the SDK were not compliant, and on top of it, it's also a violation. The privacy was not in line, was actually done with the SDK, which is 3 violations. You have to make sure that what you do in the privacy policy first is in line with the SDK are doing, and then we will see whether this privacy and this SDK use is in line with the GDPR, which is another question.
Okay.
You can't just cover your ass by just saying, oh, we just have this practice in privacy information, and then have like thousands of other SDKs which are not covered by the privacy policy and not even referring to the privacy policy themselves.
Okay, thank you very much. I hope, I'm sure now the viewers have more clear infos about how to make their SDK privacy compliant. So thank you very much, and have a nice day.
You too, bye-bye.